So, welcome everyone. Um, and as you know, this webinar will be covering the new model music services agreement that we've just released, drafted um, by Byron over at Edwards Law, which is one of Toronto is the center of the universe after all. One of Canada's leading entertainment law firms. They also were responsible for the model commissioning contract, which you can also find on our website. That is one of the first things I think Byron will get into is why do we have these two contracts now, and what as he goes through this presentation, he will be explaining sort of when it's appropriate to use that very specific agreement and when it's more appropriate to use this very flexible um, agreement. So don't think about this as replacing the existing contract. Think of them as two sort of complementary documents that can be used in various situations. Um, just before we get going, the head office of the Canadian League of Composers is located in Takaranto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and it's now home to many diverse First Nations, Inuit, and Métis peoples. It is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. Um, and just a bit about Byron before I turn it over to him, because he's kind of going to run the show. Um, Byron's an entertainment lawyer and partner at Edwards Creative Law. He focuses on music law and works with recording artists, producers, managers, music service businesses, and festivals. And before law school, he was a television and new media producer. So if anyone's looking to switch careers from music to law, you can always do that. Um, He's based in Ottawa. He works with clients right across the country, and he's also a board member of City Folk and a member of Music BC and Caris. I hope I'm saying that correctly. And he was awarded the Community Impact Award at the inaugural Capital Music Awards. Just one quick bit of housekeeping. Byron's going to go through a slideshow, and like I said, he's going to handle most of the business. If you just feel free, if you have a question, you can pop your hand up. If you think it's like relevant to what we're talking about, you can pop it in the chat, and I'll get Byron's attention and we can cover it. Otherwise, we will leave time at the end as well to answer any questions that you might have. So, without any further ado, I will shut up and I'm going to turn it over to Byron.
Thanks so much, August. Appreciate being back. A couple of years ago or so, I did a presentation with a colleague about the music commissioning agreement. And since then, we thought, let's put together another agreement regarding some other situations. And so, in terms of housekeeping stuff, just as a reminder, or for you to know for the first time, that this discussion is not legal advice. We're talking about legal information about an agreement. Using the agreement doesn't mean that I am personally providing you legal advice about your situation, but along with August and the organization, we developed a template as a starting point with respect to circumstances for which you could edit the template and use it. But I don't know the exact situation that you're in. Every situation is different, but every situation needs a starting point. And so the starting point are these two templates. And so that's just a little bit about that. With respect to the music services agreement, the context was to think about a couple kind of main situations. Number one is that you are a composer hired to do something like an arrangement or an orchestration for someone else's work, not an original work that you're creating, that you're being commissioned. That'd be the commission agreement. We're not talking about a film score or a TV score. That's really a film and TV agreement, which is a separate kind of beast. There's some similarities for sure, but that's not what this is. So you are the composer, you are a composer, and you're hired to assist with someone else's work, for example, to do an arrangement of a work, orchestration of a work, etc. That's kind of category one. Category two is you're putting yourself in the position of hiring someone else. So you're hiring someone to contribute to what you're doing. So put yourself in kind of both shoes. You're a composer that is being hired to do some musical contributions, to create some, to provide your skills on something that exists, or you're hiring someone to help you out with what you're doing. And so it goes both ways. You're the engager, you're the person who's contracting someone else, or you're the person who's providing the services. You're either providing the services or you're engaging someone to provide the services to you. So as we go through the agreement, we'll think about, what if you're the one who's providing the services, or what if you're the one who's getting the services from somebody else. The goal of this agreement template, similar to the last one, is to be pretty balanced between the parties. It's not extremely one-sided with, favorable to one side or the other. It's really just to set the stage for how two parties, two people, can govern their arrangement, no pun intended, with each other. And so what I'm going to do is I'm going to share my screen here, and really what you'll see on screen is just kind of piece by piece of this musical services agreement. I'll talk through each of the kind of major parts of the agreement, but pretty much the entire agreement almost is going to be, on these slides one by one, and we'll go through each component of it. The other kind of overriding comment is that the schedule to the agreement, meaning like the last page of the agreement, is really where you add in some of the like meat and potatoes, so to speak, of like the specific details of your specific arrangement, for which a template could really never know in advance of what those details would be. And we'll get into that. So, a lot of the conversation is about the more general pieces of the agreement. And then as we get into the very specific parts of it, we'll talk about the kinds of things that you could add into your agreement to ensure that it reflects your specific situation. And this is pretty common with a lot of agreements. There's kind of general terms and then more specific terms to your situation. So this structure isn't a, music composing specific type of way it's framed. This is how agreements work in general. Agreements work in general where someone makes an offer, someone accepts that offer or not. But if you don't accept the offer, there's no deal. But an enforceable agreement is where you have someone making an offer, someone accepting that offer, and both sides getting something out of it. So an agreement template that could be used in pretty much all cases could be, I am giving you this, you are giving me this, or I've offered this, you've accepted this, and here's what we're each getting. It could be a template for anything, buying some equipment, or mowing someone's lawn. I mean, I'm just thinking of random examples here, but really that's the basic of it, of any agreement. And so, but with respect to creating musical works, there's some specific nuances that we'll get into of why they're in this kind of a template. So, as I said, I'm going to jump to the PowerPoint here. The PowerPoint is really, essentially like a nice copy and paste of the agreement. So you don't have to, take screenshots or anything. The agreement is already on the website. So really, this is just a time to listen and think about questions you might have, with the goal that after this presentation, you'll feel more comfortable using this agreement for the first time, or for maybe the second time, than you were before, and kind of when to use it, and also when it's really not the right agreement for your situation. So I'm going to share my screen here. And just for clarity, as August already knows, once I've shared it, I won't be able to actually see too much other than the slides themselves. So, if you have a question, August will jump on in. Probably the best way to frame it is that after each section, if there is any questions from anyone attending, or from August, from you, August will jump in, ask the question. Perhaps the best way to do it is just to write down your question in a few words, and August and I will chat about your question. So there we go. So the starting point is, who is entering into this agreement? And in this template, the contractor is the person or company who is hiring the composer And the second party is the composer, who is the party or person who's creating the relevant music. The word party, really means an individual or a company who's entering into an agreement. In general, general comment about this for contracts generally is that a party could be an individual or a partnership or an entity such as a corporation. So it is definitely possible that the composer is one human being, or perhaps it's two people who work together as a duo of, music creators. The contractor might be an individual. It might be a partnership, for example, again, like two people working in partnership together, or it could be a corporation. So, and also technically, not even technically, but practically speaking, a composer could be a corporation that's providing the services of you as an individual. So the parties entering into this agreement are either you or you and someone else. Well, there's more than just one person, but for each of the contractor or composer, it's either you or you and someone else, or a company that you or someone else is connected to. And by company, I'm referring to a corporation, but a company could also be a sole proprietorship of someone. So it could be Byron Pascoe carrying on business as Byron Pascoe Composition Company. That's a company. It's not incorporated. Maybe if I've incorporated a company, it's like Byron Pascoe Music Services Inc. So a lot of options. But the starting point is, are you the one who is engaging, hiring the composer? Or in this contract, are you the one doing the composition? Okay. So there we go. You might be either one, depending on the situation. Okay. So the starting point of this agreement is that we are defining the terms of compositions and recordings. And when a word has quotes at the beginning and end of the word, it means that it's a defined term in the agreement. So whenever we say the word compositions in this agreement, it's referring to what it says here. The compositions written in part or full by composer within the scope of the services. Sorry, I need to add in the word "see" there. It just says services. That is not correct. So noting the typo for future, we'll change that. The compositions are literally the compositions being created in the scope of the services. The services is something that's going to be defined throughout this agreement. The recordings is the actual, sometimes called master recordings or masters or recordings. So these are the physical or digital recordings of the composition. I realize that defining compositions with the word composition and defining recording with the word recording isn't super helpful, but it is a starting point of how these words are being defined, and they are connected to the services that are outlined in this agreement. So this agreement is starting by saying that the composer will compose and deliver to contractor the deliverables set out in Schedule A and the provisions of this agreement. So, I've talked about the schedule. Schedule A is where we outline a lot more of the details surrounding what is actually being done. And like the third part there says, composer shall deliver the deliverables by the date set out in Section A. Deliverables is going to be defined later on. And it says changes to the compositions, including their name, require composer's prior written approval. So in the way this is drafted currently, and of course you can change anything for your situation, but in this version of the template, if the party engaging the services of the composer wants to change the name of a composition, they need the approval of the composer. Now, if the composer is arranging or adapting someone else's existing music, which is kind of a common case here, then we might not put this section in, this last part, because we don't want to give the composer the right to change the name of a composition if it already exists. So, there are some things that are important. I mean, it's important to read the template if you're going to use it. It's important to edit the template with respect to the schedule of what is specifically happening. And there may be some things in the template sometimes that need to be removed or may need to be added based on your circumstances. But the goal was to make this as useful as possible for the for common situations. But it is still important to read the agreement to make sure that it's consistent with what is going on. And if you have a question, that's where people like August and myself can come in to answer questions you have about ensuring that the agreement is still consistent with what you want to accomplish. Before I jump into financial compensation here, August, anything to add or any questions to go over?
I'm not seeing any questions, but I
Okay.
would say just like emphasize that sort of flexibility thing here. So for
Yeah.
example, like just, and you can correct me if I say anything dumb here, but for example, let's say that this was a composer hiring someone to perform on a recording gig. You would just simply be changing the language around so that, performer
Right.
shall agree to perform uh the works as you would adjust the language and maybe deliver it to contractor then becomes composer, so perform then the
Yeah.
you're just adjusting the language to the reality. Composer in that case could be engraver shall produce set of parts and score to deliver to composers, the deliverables listed, and etc etc. So um yeah, I just like just to kind of put some concrete examples on to this particular part of how you might adjust things around.
Yep. Totally
So
agreed. And yeah, the key takeaway, or one of the things that you said there that I want to amplify is the word flexibility. The goal here is to have a starting point template that can be flexible for your situations, and sometimes that may mean also changing the names of the parties to reflect further, what someone is doing. If we're talking about a performer as opposed to a composer, we would change the word, composer for performer. Um, Sometimes in agreements, you don't list kind of the role that someone has, but you list their last name. So, it might say that, Smith is engaging Johnson, like you could put whatever you want. You could put party A,
yeah,
party B. There's ultimate flexibility. And that's not something that's limited to this agreement. Any agreement, really, I mean, most agreements anyway, you can call the different parties whatever you want to call them. And it's generally either their name or their role. Um, Oftentimes you have the word company as a party if it's an organization. So there's a lot of flexibility generally, including with this template. So jumping to the next topic here, financial compensation. This section is about what is the person doing the services being paid, what is their fee, and when are they being paid. And oftentimes with agreements, in general, they might say that the party is being paid a certain fee and that's it. The problem with that is that the clarity around when someone is paid is really important, because without it, it can lead to inconsistent expectations between the parties about when they're being paid. And so this is a starting point for that section. There is what's called you see the line there at the beginning part here? This is what I'd call or what people call a placeholder. This is holding the place of what the number will be. You can write the number out however you want. There are some kind of common ways to write out the number. For example, if we're talking about $1,000 as a nice clean number to put here, you could write out the words $1,000. If someone is in Canada and someone else somewhere else in the world, or even if they're all in Canada, I highly recommend listing the actual currency. So you could write out 1,000 Canadian dollars, or you could put the number sign, the number 1000, and then add on Canadian or CAD or CDN. For the US, if there's US funds involved, usually it's referred to as USD or United States dollars. There's no rule on how it has to be. But those are some of the options. Oftentimes, how you might see it is that you spell out the word, and then in brackets you put the numeric number. So you might spell out the word 1,000 written out, and then in brackets you have the dollar sign, you have a one, you have a comma, you have 3 zeros, and then you put CAD and you close brackets. The thing to watch out for that, and I saw this the other day when I was reading a contract, is that sometimes people kind of make an error and have one number written out and one number in numeric numbers, and that just causes a whole other aspect of confusion. So it's a good idea just to be super clear about the amount and the currency to reduce any sort of issues in future. As for how the money is paid or when the money is paid, also a very important topic. As the person who is receiving money in return for providing a service, generally speaking, the preference rather is to receive more money earlier and less money later. And as the person who's paying money to someone else to do some work, preferably you want to, in most cases, pay less now and pay more later. Sometimes there is a percentage of the funds that are paid when the agreement is signed. Sometimes it might say upon full execution of this agreement. It probably wouldn't say partial. You probably need both parties to sign, or all parties to sign before that initial payment is due. And in this case, I put 50% of the compensation, and compensation is defined above as that number that you're going to add in. I wrote 50% of the compensation. So let's say the fee was $1,000. I would write in here $500, then in brackets 50% of the compensation plus HST or GST upon execution. Again, there's a variety of ways that this could be written. Instead, you could just say 50% of the compensation and not spell out the number, or you could just write the number and not put 50% of the compensation. It's up to you. I think that just having the clarity generally of spelling it out of what's being paid reduces potential conflict later, and therefore I'm a fan of spelling things out, especially about all things, but important things about when someone is paid. I wrote here 50% upon execution of the agreement, 20% upon something, 20% upon something else, and then 10% within a certain number of days of the final delivery of the musical work. With respect to those placeholders at B and C, they could be whatever is relevant. And it really depends on what is being done. If someone is helping you to adapt 10 songs, or if you are adapting 10 songs for someone, and there's, add in a lot of other clarity about what you're doing, but let's say there's 10 songs that you're working on. Perhaps the way this is set up is that you're paid 50% once you've signed the agreement, and then maybe you're paid 20% once you've submitted 5 of the songs, and then 20% once you've submitted 7 or 8 or maybe 9, and then the last 10% once you've submitted everything upon final delivery. So that's one way that it could work. The lower amount of money, you typically wouldn't have 4 different payment intervals. It's more likely that you'd get 50% or a percentage, maybe 50, maybe less, maybe more, when you're starting, and then the rest of it once you're done everything. The higher the amount of money, the longer it's going to take, the more intricate the more let's say the more stuff that you're doing, and the higher the amount of the fee, or that you're paying someone to do, then it's more likely that you'd have 3, maybe 4 payment triggers. But there's no rule on what it has to be. It could be that you're paid or paying someone fully upfront when they've signed the agreement. It could be that they're being paid fully, or you're getting paid fully when you're done everything. That's legal. It may not be so fair to get paid once you've delivered everything, but there's a variety of options. A key component is what is how we're dealing with the last payment. And if we're talking about if it's based on delivery, the key question I always have is, okay, well, who decides, or like, what does it mean? Does it mean that I've just delivered, which is what it says here, or does it mean that it has to be accepted by the person who I'm giving it to? So think about, in your situation, if there's money being paid once everything is done, who's deciding? Is it just what I've delivered, which it says here, or should it mean that final delivery as confirmed by the contractor? So this is actually the way this is structured in this exact sentence. It's a little bit more favorable to the party who's doing the composition work, but it could easily be changed to reflect the other situation. Let's talk about HST, GST. Depending on where the parties live in Canada or not in Canada, that would impact what the tax obligations are, if any. This isn't a session specifically about tax and financial considerations, but it's always good to ensure that you're familiar with when you are required to get a tax number, and if you're paying tax to someone, you want to make sure that they're actually supposed to be collecting tax too. Taxes, it's a whole thing. I'm not going to get into it too much, but the key portion, the key point here is that I wrote, plus HST or GST, kind of pick the relevant one, if applicable. It's not paid if it's not applicable. It's not paid if it's legally not required to be paid. And you don't pay tax if someone isn't a tax collector. So that is something that is relevant. If you're being paid and you expect to be paid, plus tax, then you want to make sure that it says that you're being paid the fee plus tax, not that it's including tax, but that it's plus tax. So that's a consideration. I've seen that in different musical situations where people are paid a fee. Usually it's like, well, the first example that comes to mind is someone's being paid a fee to perform at like a festival or a show. And, back to the $1,000 example, let's say that they're paid $1,000. They expect to get paid 1,000 plus HST, but they're given 1,000 and they're told, well, that includes HST. If you collect HST, then it's really more like, $890 plus HST. So important to think about the tax thing. I'll leave it at that with tax. Bottom line on this, there's flexibility around clearly you have to agree on what the fee is. There's flexibility and room for negotiation about when you're paid. And you want to think about just what makes sense in this situation regarding the intervals of payment. Does it make sense for you? Does it make sense for them? You don't want to commit to something. If you're paying someone else, you want to make sure you have the money to pay them by the time that you owe them the money. So there's some cash flow considerations. There's some motivation considerations. Why do you put a lot of percentage at the end? If you're hiring someone, you put some money at the end to give them motivation to finish the job. And if I were looking at these numbers and I was the company hiring a composer, I would say I want to put a higher percentage with his last payment, because I want to have more incentive on the composer to get things done and completed. And I also would say I want it to be within let's say 10 days of my confirmation of that it's been final, that delivery has happened. So I'll leave it at that. Actually, there's more on financial compensation. I forgot. The compensation. So here's some other aspects that may be relevant in your situation. Compensation or any installment of it shall be non-refundable, meaning that let's say that the person did half the job and got paid that first payment, maybe this first and two payments, and they didn't finish anything. The way this is set up as something to consider for your situation, it's that it's non-refundable. In the alternative situation, so this is composer friendly, this clause here. If you're hiring the composer and you want it to be more balanced towards you might say that if they don't deliver everything, then they have to refund everything that they were paid. So the way this is set up right now is a more composer friendly thing. We can't have everything be balanced, and this was just some of the decisions that were made as a starting point. So that's what we have. There's been reference to the deliverables. They're defined in Schedule A. If a payment is late, the composer may choose to not continue to provide services, and no additional rights will be granted until a payment is made. So if you're the composer and you haven't been paid on time, the way this is set up, again, this is another kind of more composer-friendly comment, it's that this agreement gives you the ability to pause on doing work until you're paid, so that the other party doesn't say, well, just keep doing, keep doing everything, and once you've delivered, then I'll pay you. No. If they want you to continue, then they need to pay you for the work you've already submitted based on your payment schedule. The last sentence here is contractors shall be solely responsible for any costs, fees, royalties, or other compensation due to third parties. So, relating to just what's going on overall, the context here is that the composer has a very limited role. They are not, this is a bit different. This is one of the examples of where it's different from the whole commission agreement, because in the commission agreement, you might be hired to create a full, much more elaborate and full work that you wrote, and you may be hiring people to perform the work under certain circumstances. So in this case, with this clause here, the last line, the way it was set up for review to make sure it works for you is that the contractor is responsible for everything else, not you. August, any comments on these two slides here?
I think the only two things that come to mind are just one thing. When I look at the schedule of payments, a common way that you might see that done would also include things like drafts or revisions, or so you might get your certain amount upon execution and then a certain amount upon delivery of a first draft. That would also be a common thing to see. And then I would just say overall, like, the version of the contract that I think you're all looking at as is right now is one that if you were hired as an arranger or orchestrator, this, like, you actually wouldn't have to change very much. The sort of default position here is composer friendly when composers being hired. If you want to turn the contract into composer doing the hiring, you're going to have a few more adjustments to make, because that's sort of, it's a flexible contract, but does have like a default starting state, which is since it was commissioned by the Canadian League of Composers, is favorable to the composer.
Was there anything else? Was that cover both things? Yeah. Oh yeah. There's two things you just mentioned. So yeah, that covers both. But yeah, we're on the same page. Regarding royalties, this is also something that this is the starting point. What we might actually do is we might just put placeholders for all the percentages, just to make it even more flexible. So that depending on your situation, of what's happening, the parties involved in the agreement figure out what percentages of the composition are being owned. Because if a composition already exists and you are adapting it, for example, you're not going to own the whole composition. That's not reasonable in the circumstances. So this first part here, can you see my cursor as I go over stuff? Can you see that?
Yes, we can.
Okay, excellent. So the first part is really about the composition ownership, and I'll change this to a placeholder just so it can really be even further flexible. The second part is about recordings of the compositions, and how they're distributed, which could be either that they're not really, or maybe a very significant piece of what's happening. And so here I have a placeholder already of what the contractor is paying the composer. That might be 0%. It might be something more than 0%. But this in a very broad summarized way outlines the ownership of these compositions that are being prepared, and also about any money generated from the recordings of those compositions. So this is the starting point to add in the details about those specific pieces. If you are someone hiring someone else to work on your music, your project, you might say to them that they're being compensated by way of their fee, and they're agreeing to take zero future royalties. Or you might say, I don't have as much money for you as a composer as I would have liked to. That you're worth more than what I can afford, so I'm going to propose that I pay you what I can afford to pay you, but that we'll share the potential future royalties more in a more balanced way. So that's a common way to deal with the value that someone's providing, the money available to pay them, and the potential future royalties depending on what is being made and how it's being used, knowing that there really is no guarantee that there will ever be any kind of future royalties with respect to the composition or the recording. It really depends on what's happening. So this is the other piece that fits in with the compensation part of it. Upfront guaranteed fees here, and then we're talking about what some people call contingent compensation. It's contingent upon certain things happening, namely the music being used in certain ways. Anything you want to add there, August? I mean, these are all really important things, and it's like, the goal as well with this template was let's keep it short-ish. Let's keep it, broad. You can write an agreement. Any agreement can be, 1 page or 100 pages. And so the goal was really, let's keep things broad, but this is this piece of it. And in some music agreements, I'm thinking of just reading a publishing agreement. A paragraph like this could be, 1 or 2 pages in a much more elaborate agreement, or it might not be talked about at all if someone is not entitled to anything in future. So this is where we landed. What I think made sense for the circumstances. So I'll just keep going on here. The other piece of it is what the credit is that you are giving or that you're getting. The starting point here that I highlighted is that you're credited as a composer, but adjust this as relevant. And this may be another example where we just replace the word composer with a placeholder so you can add in the word. Again, we're trying to accomplish a few things at the exact same time here, but the most common situation is that the composer is the person being hired, whether it's you or someone else, and that is the exact credit that they're being given as a composer because that's their role. So this can, like anything else, it could be adjusted. The context is that it's wherever credit is provided. Like that's a key thing. If other people are getting credits or being credited related to what's happening, then you should be included. But sometimes there aren't credits that are as obvious as in other situations. It just depends on the situation that you're in, and wherever such credit is provided is a pretty reasonable, balanced situation, so that the contractor includes the composer with everyone else. And if there isn't other people credited, then it's let's say less of a requirement because it's not provided for anybody. I'll leave it at that, but again, it depends on the circumstances where you may want to. There may be it may be relevant to provide additional credit related obligations and entitlements.
Can I jump in for 2 seconds?
Yeah.
Just to sort of bring those back to our bring the credit thing back to our original kind of 2 circumstances or theoretical examples of like you the composer being hired as to do an arrangement, or you as a composer hiring performers. you would want to be credited as probably the arranger in arranging, so you wouldn't be credited as the composer. And
Right.
but you also probably want to set up a situation where you are, if you are hiring the performers, giving them credit. However, another example, like if you're hiring an engraver or copyist, they don't normally get credit or public credit for their work. So just to just to put some real world bones on
Yep.
what you just described.
For sure. We're on the same page, and yeah, it's another example of why it's important to read through the template to see if it matches your situation, and then adjusting it um, if needed. With us, incorporating into the template some of the more common situations, but it's just not always going to be relevant all the time. And the thing is that you can also, like, there's no rule that any of these clauses are in the agreement. If in your situation it just doesn't make sense to promise any kind of credit, you could just remove the whole section, or you can add it in and say that there is no credit obligation. Okay, so moving on, this section here is the most wordiest of them all, as in just a lot of like text here. But at the end of the day, what we're talking about is the actual intellectual property that is being transferred from one party to the other. And what I did here was I added in the headings of recordings, and then on the next page of compositions. I highlighted a few words here or there, and I wanted to focus on a couple of things, because these are the things that I think are most helpful to or relevant for this discussion. So, a key thing when you are providing services or hiring someone to do a service is what triggers rights to be transferred. If you are providing services in any kind of realm, preferably for you, if you're providing services, that you are only granting the rights in what you've made once you are paid. So I'll say that again, just to kind of amplify that. If you're providing services to somebody else, ideally, they don't own any aspect of what you did or have the rights to use any aspect of what you did until you are paid. The flip side is that if you are engaging someone else to do something for you, preferably you are earning the ownership or the rights that are being granted as soon as the work is being made, and you aren't waiting until you've paid someone to get the right to do whatever it is you're getting. So, as a person who is providing services, ideally you have this part here in yellow, that once compensation has been received by you, then blah blah blah. Um, on the flip side, preferably it would not say this. It would actually say something else, namely that the rights are owned as they are created. But from the context of starting off with a little bit in favor of the composer, anyway, that's why this was included. The last sentence here I highlighted as well. I said the rights granted are retroactive to initial commencement of services. Now it's saying the effective date. So, what does that mean? It means that if the date of the agreement is later than when the composer, the person providing the services, actually started to do the thing that they are doing, that's okay. It still covers that work done before the agreement, and that's further amplified by this other sentence here. This comes up in just a variety of situations. I'd say like the first line is a bit more important, but I also wanted to highlight this as kind of a takeaway of just thinking about the concept that the date of the agreement we don't want the date of the agreement to really impact the practical outcomes of your arrangement with somebody else. What's in between this sandwich of yellow, bread here? This is the grant of rights to for the person who is hiring the composer to own the recordings that are being made. In the second to last sentence here, it says the composer hereby irrevocably waives in favor of contractor and successors the benefits of the composer's moral rights. So moral rights is a concept that is probably a concept that I explain to clients and other parties more than any other aspect of any agreement. The moral rights are the rights of attribution and integrity, and these are rights that cannot be given but can be given up, which is why we use the language of waiving. You're waiving your moral rights. The concept here, or the key reason why this is here, is because if the composer later feels that their integrity has been negatively impacted by the use of what they made, if the composer does not waive their moral rights, they could seek they could go to a court. It's not so easy to do, but you can do it, and get a court to confirm that because what the contractor did with your work negatively impacts your integrity, they need to stop what they're doing. Now, that might seem like, oh, I want to keep that right. I wouldn't want to give up that right. The problem is that the reality is that the way that kind of the ecosystem works with people creating works, whether it's in music or film and TV or books or kind of anything else creative, if everyone had the ability to later kind of take back permission, it would really lead to there being far less investment in the creation of artistic works, because people would be concerned about the fact that they may not be able to use this creative work that they commissioned or commissioned, that they may not be able to use it in future. So I didn't come up with this, but like the world generally came up with this concept, or someone came up with this concept, and it's in a lot of agreements that that the composer or the person creating the work isn't going to go after people later because isn't going to go after who's ever using the work in a way that might negatively impact their integrity. They're not going to try to stop them. They're not going to pursue this avenue which could stop someone from doing what they're doing with your work. It's a bit of a mouthful, but it may seem like negative to the composer, and it is a restriction on what they can do. It's just kind of the way it is. And as if you're playing the role of a contractor, you're happy this is here. And if you're a composer, the takeaway is like, this is just kind of how it is. Unfortunately, there's other aspects of the agreement that are going to be in your favor, like being paid for your services and being credited. But this is here, and it is a common question that people ask about and are wondering, what does this even mean? So in a very summarized sense, there I explain that, but that's why that is here in this contract. The related piece of it, the way this is framed, this template, is that the composer is earning is giving the right to use their compositions, but the way this is framed, as between the composer and the contractor, the copyright in the composition, and we may change this to like the part of the composition, but it stays with the composer. So the composer is giving the right to use the composition, but they're earning. We talk about their percentage of the composition here, but the big divide in this version of the agreement is that the engager is owning the recordings, but the composer still owns their contributions to the composition. That may not be relevant in your situation. If you're hiring someone and you want to own everything, then we would put it all together, and we would this would be changed to reflect the fact that instead of just recordings, it's recordings and the compositions that are being assigned. So the way this is set up is that there's a distinction between the rights in the recordings and the rights in the composition. That is either going to work for you. If you're the composer, that's preferable for you. If you're the engager or the contractor, that may or may not be relevant. So that's the distinction, and that's where may need to change based on your circumstances. Hopefully for you as a composer, it doesn't change from that. August, do you have any comments about this?
No.
Okay. So I'll just keep going, and we can come back to it if we have any questions later. In terms of a breach, the concept of a breach is that if two parties to a contract, any kind of contract, if one of them feels that the other person, is offside, if it has done something they're not supposed to do, legal jargon being breached the agreement, then one party says to the other, you did something you weren't supposed to do, or you didn't do something you were supposed to do, and you have 30 days to fix it. And in this case, it says that if you haven't paid within 15 days, then you have 30 days. But if it's 15, but if it's not, if it's because you haven't paid me as the composer, then you have 15 days to fix this issue, to cure this breach, this cure period. And what this agreement says is that either party may terminate this agreement upon failure of the other party to cure a breach within the cure period. So what this means is that if you're the composer and you're engaged to do this composition related work, and you got your first payment, but you didn't get your second payment, and you've given notice to say, hey, you're supposed to pay me, and they don't pay you for 15 days, this gives you the ability to end the arrangement. And if you still, the agreement, and if you have this clause that we talked about earlier, that all payments are non-refundable, that means that if you're paid first payment, paid second payment, but you weren't paid third payment, and you give notice, and 15 days later you still haven't been paid, you could say, well, I'm terminating this agreement. I'm ending it. And by the way, the money you already gave me is non-refundable. So this is an example of how with contracts, including this one, we're connecting a few different aspects of the agreement all together to get, a result that is hopefully favorable to you. And the related point is that just different aspects of the same agreement, they do connect to each other. It's a bit of a puzzle, whereby nothing is kind of read on its own. It is all connected to something else in the agreement, which isn't meant to be confusing. That's just kind of the way it is, because otherwise every paragraph or every topic in the agreement would just be way longer because they have to explain everything. But if someone wants to know what happens if you terminate, like what happens, am I allowed to keep the money? It's like, well, it doesn't say that here, but it does say that back here. So that's just an example of how things just connect to each other. In most agreements, when someone is creating something of an intellectual property nature, there's generally some pretty standard confirmations, representations, and warranties is a confirmation that someone is making to the other party. And generally speaking, what it is saying is that, or what is common, is that both parties are agreeing that they have the authority to enter into this agreement and to grant the rights that they're providing and to provide the services. And so if you are engaging a contractor to do something, you want to make sure that they actually, what they're giving you, that they actually created. And so that's dealt with in the concept that the composer has the right to grant you the rights that they're granting to you. It goes on, like that concept is also common here, or is relevant in the second sentence, where it says that the composer represents and warrants that their contributions shall not infringe upon or violate any rights of any third party or offend any statute or law, including any, like this whole sentence. What this is saying is that what the composer has created is original to them. And if it's not original to them, then what happens? If the composer just, let's use the word steals something, they steal or borrow without permission what someone else created, they've confirmed that what they did was original, so they're offside there. So how do we deal with it? What this part of the section is saying is that if you were not correct, or you're not accurate, or not telling the truth about these representations, if the other party has some kind of loss because of it, then you're obligated to cover them for their loss. That's what an indemnity is someone is covering someone else, is making someone else, let's say, whole, or like helping to ensure that any kind of damages they had are fixed, are cured, are dealt with. But this exists here, but the expectation is that if you are the composer, you are creating something that's original to you. And if you are engaging a composer, then you're going to do some due diligence to make sure that they are someone who is reputable and is not going to take from somebody else. But these concepts are here because not only they're not used every time, obviously, but they're here when you need them. I was talking to another lawyer this morning about a unrelated situation in which we were specifically talking about the representations and the indemnity. And I was using that concept to help to advocate for my client to ensure that it's kind of a long story, which I can't get into, obviously, but the point is that this concept of representations and warranties and indemnity, or like confirmations and covering for people, is a very common element of many agreements. And it's important to understand what you are confirming. And if someone has done something that they shouldn't have done, or if they've told you something that you find out later is not actually correct, and you're damaged because of it, if you're hiring a composer and they deliver some work for you that clearly that you find out later wasn't done by them but done by somebody else, and that other person came after you to get paid for their work, you could use this section to try to get covered for your losses by the person you hired. I'll leave it at that for this section here. Confidentiality is a common clause in a lot of agreements, including this template, where both parties are confirming that what like the terms of this agreement are confidential. Why would that be relevant? So if you are providing services to different people, you may not want everybody to know what your rates are to do things. And so it's reasonable that both parties are confirming that the details of this agreement are not going to be shared with other people. There are some exceptions to the rule. They can tell their lawyer. They can use it if they need to enforce their rights. For example, if they weren't paid, then they can use this agreement in like a court setting to confirm that they should have been paid. But otherwise, it needs to keep, for the most part, otherwise certain information needs to be held as confidential and not be disclosed to other people. The last part of a lot of agreements is what's called sometimes called a general section, sometimes called miscellaneous. You can hide anything. I mean, not hide, but just because something is in the general or miscellaneous section doesn't mean that it's actually not that important. It's actually very important. The reason why it might be called general is because these are even more generalized concepts that are in a lot of agreements, and so it's just kind of packaged together nicely in a section called general. But these are all really important concepts to know about, regardless of your type of agreement. So let's walk through some of these. So the first one says that this agreement replaces all previous discussions. And that's a really good thing, because you don't want someone to say, well, you told me one thing, the agreement said something else, so I'm not really sure what's going on. No, what's in the agreement is your agreement. What's in your written agreement is your agreement, not what someone might have said in order to have a discussion with you about what you might be doing together. What's important and all that matters legally is what is actually in the agreement. So if someone promises you something, if you're a composer and you are promised something specific relating to what you're doing for this contractor, and it's not in the agreement, you want to add it into the agreement. You want to clarify whatever it is you were promised, because those promises that you were told beforehand are not part of your deal unless they are actually in the agreement, in the written agreement. So usually when someone says, hey, can you read this agreement for me? I might say, well, what are your expectations about what this agreement should be? What are your expectations about what you're getting out of it. What were you promised? Why are you doing this? And we want to make sure that those reasons are in your actual agreement. Um, Moving on, a related concept that agreements can only be updated in writing. The governing law is very important. If you're based in Ontario and you're hiring someone based in Saskatchewan or New Brunswick, you probably want the agreement to be governed by the law of the province that you live in, so that if you have to sue someone or be sued, you're dealing with your local law, which doesn't mean that it's completely different anywhere else in Canada, but it just you would rather be dealing with the court system in your own province as opposed to going somewhere else in the country. So generally speaking, you no matter who you are in a contract, you want the contract to be governed by the province or territory where you live. Oftentimes, whoever is paying someone else has a bit more leverage about having it be based where they are. But it depends on the circumstances, and so I'll leave it at that. But so. Let's say you live in Toronto. You'd say that the way you'd fill this in is you'd say the province of Ontario, and then the courts in Toronto, Ontario. So that you'd put your province, then your city and province is how you'd fill this out. The last section relates to like other related parties that might get the rights. If you're providing services to someone's company, and they sell the company to someone else or sell the agreement, they own what you did. So you're not always going to forever be dealing with the same exact human being that you dealt with when you initially discussed an opportunity. You might end up having your work be owned or having rights granted to some future unknown party. So that's a common clause, and it's just a general consideration to be aware of. A few more here. This says if something is essentially like illegal, which is not that common at all, but if there's something in this agreement that would make it, among other things, illegal, the rest of the contract is still legal. All notices need to be in writing. So let's say you need to give notice about that cure provision we talked about. This is the way that you can officially give notice to somebody else. It's really important to be able to know what the ways are that you can provide notice to someone or be notified by someone else. This is not like a court thing where you're served by a process server. This is just like really the main thing here is about if you're giving notice to the other party that you weren't paid, or if they're giving notice to you that they weren't paid. That's kind of the common type this would be used in the context of triggering that cure period to be able to eventually terminate the agreement if you want to. This says here that the relationship is that you're independent parties. You're not. This is not an employer relationship. And you've each had the opportunity to obtain independent legal advice about your situation. ILI is independent legal advice. This is in a lot of agreements where you're just confirming that you had the opportunity to get legal advice if you wanted to get it. Now here's the key thing that really connects your situation to the agreement, and we've talked about this. So this is where you put in the details of what's actually going on with your specific circumstances. Insert the general description of the services. These are just some other, delivery date. I mean, the media really depends entirely. All this depends entirely on what is actually happening. And the point here was to add in a lot of room for flexibility, but adding even, just more details, more and more details that relate to your situation. The delivery date and delivery schedule kind of like they're related concepts. The whole point is, when does this have to be done? What is someone providing to someone else? what is the scope of work? So in this context, sometimes we refer to this as like an SOW, or scope of work, or statement of work, both kind of work. But however you want to frame it, and we framed it as Schedule A, it's the much more specific details about what is actually happening. And this could be in the form of you just writing in the answers. It could be in the form of you putting in a document that was created by somebody that outlined what's happening. There's no rules. Just the key thing is that we are connecting the tasks with the agreement. And we are, in this case, we're defining the word services, like whatever the services are, they're being defined as the word services. But this is where you connect the details of what you're doing to the actual agreement. So that covers it. I feel, we've talked for an hour about some of these things, but I could clearly, some of them we could talk more about. Some there isn't too much more to say, and it really, a lot of it is, okay, you have this starting point. What is the best way to use this for your specific circumstances? And I think that, one second here, I think that a good thing to do before you have a specific type of reason to use this agreement is just to read the agreement and think about, okay, if I'm a composer being hired to do something, or if I'm hiring someone else to do something for me, just think of an example of a scenario of where you might fit in on either side, and read through the agreement and think about the types of questions that you should be asking yourself or asking others, or prepared to be asked some questions, just to figure out like the scope of what's going on, so that when you're ready to use the agreement, you've already spent some more time thinking about how you might use it to meet your needs.
I'm going to jump in and I'm going to say,
Jump
hey,
in.
that was a lot of good information. And it was a lot of information, but I think
Yeah.
it was very helpful and very good to go through kind of everything line by line. I would say before, because I know there's two questions that we got pre-submitted. I have one question that might be complicated, but I think is worth bringing up just because I think it's relevant given one of our specific examples that we used.
Yeah.
But I would also just start by saying, when the time comes for anyone to go use this contract, like the CLC exists and I exist to kind of help you through that. If you have questions, how to use the contract, what to change, if you need it looked over, like you can always email me or whomever the general manager of the CLC is. And part of our job is to kind of help you work with the contract and answer any questions you have. So sorry, let me look over at my other screen because there were two questions. So this first one is basically, if you are a composer and you're in a position where there's two tasks. So let's say you've been commissioned, and this would go back to the commissioning contract, but could also apply here in the context of orchestration arrangement. You've been contracted to either commission to write a new work or to do an arrangement, but you've also been asked as part of that to do the task of copying and engraving. Um, and just a reminder for everyone there, that should not be part of your fee for doing your composition. You should be getting paid for engraving and copying as well. That's a separate issue. Do you need multiple agreements in that situation, or is that where a situation where you might use the schedule to outline the two different roles you're playing and then adjust the financial section accordingly?
So I would say that, like, there's no rules on what it has to be. I think
Mhm.
that, like, the general common starting point is that you incorporate all of the services and all of the fees into one agreement. Um, that's what I would usually suggest. But it doesn't have to be that way. It could be either way. I just think that, generally speaking, if you're involved in multiple tasks on the same related project and it's the same parties, that it usually it makes sense just to include everything together. And that may include that you have a schedule devoted to the tasks of one particular aspect of your role, and just answer the questions again for the second part of it. Um, the key thing, I think the relevant consideration is, what happens if you end up doing one of the two roles, either by choice or by being told? And how is that going to impact the job that you did? And so there may be some additional things to add to the agreement to reflect the point that, like, I mean, the best thing to say is if I don't deliver on one thing, I'm still on side to deliver the other. I mean, we're assuming that you're going to do everything, but we don't want to have, for you as a composer, we don't want to have something be, we don't want to put you at risk of, losing out on some entitlement because something happened regarding some other part of what's going on. I know I'm being a little vague here, but like if you're expecting to do two things, and for whatever reason, one of them is not happening anymore, you still want to maintain, the other thing. So all that being said, I think it still makes sense to put it all together, but there may be some additional comment to add in the schedule, for example, that even if you're offside on one thing, you're still onside on the other. So that's one way that I would look at it. The at the end of the day here, like if you have two separate agreements that are the exact same except for the different payment schedule and services, that's okay. But like I'm kind of a fan of consolidating and keeping things as simple as possible. So the general legal answer is it depends. But I'd say in most cases, it probably makes sense to put it all together.
Elma, do you have anything to? Do you want to? Because that was your question. I just want to check this to see if you got your question answered there before moving on.
You're on mute.
You're on mute.
Yes. Um, the problem is that I use a very old software program, and the person who's commissioning me wants to also use it as an artistic part of the performance. And I do like showing off some of my skills software wise. Some of the stuff I do is kind of wild. And that's why they wanted a score that the audience can see at the same time they play.
Interesting.
I see.
And yeah, so I think I'm going to put it all in the same agreement. It'll be a little bit more complicated, but there isn't anybody else who could take over the software part. It's an old software program, Score, that I've been using since 1988. So it's going to be hard to do another person for it. But you raise a point where I should have a backup.
Well, a backup of
The software component.
if you should back up the software.
No, another person to take over if anything happens. Let's say the computer crashed.
Oh, okay.
So
Yeah.
I have another person who could take over my work in the software area, not the composition area.
Okay.
I'll
Yeah.
still do that.
Right.
But it makes me think that maybe I need a person who is a backup for me if something happens. Technically, who knows?
Yeah. Yeah. Well, so I have nothing to add on the part about like the technical deliverable, and who does what. But I think the related concept I want to amplify is the concept that the other party doesn't have rights to do anything until you're paid for everything that you've done.
Right.
And that's that. I kind of wanted to speak a lot about that one little sentence because that can go a long way in ensuring that you're more likely to be that you're just further protected. Nothing is going to fully protect anyone from everything. Like there's always there's always the ability that someone might promise something and not pay you, and you can't access them, and now you've done work and they're gone. But that's always there's always a risk. There's always a risk, even if it's someone that someone else trusts or whatever else. But the concept that you don't grant any rights to anybody until you've been paid everything, that is a helpful step, especially when you're doing multiple things and you're being paid for multiple things. So would definitely place a lot of value in having that kind of a clause included. or that kind of concept included. And would definitely want to suggest kind of pushing back on someone who doesn't want to have that concept in place, especially when you're doing different things, and especially when well, just when you're doing when you're delivering more than one thing or providing more than one service, which sounds like what you're doing. Interesting.
Thanks.
Yeah, thanks, Alma. Does sound like an interesting situation.
Yeah.
So this is I know this is a question you probably get all the time, and so feel free to answer accordingly. But
The question, did I used to have more hair? Yes. Your kind of style? No, I did not. But okay. The second question.
Yeah. What are some examples of things that you see getting, let's say, squeezed into the fine print of this question says record contracts, but I think we could probably expand that to sort of broadly music contracts that are meant to go unnoticed by unsuspecting art. Like, what are red? I guess this is the summary. Is like,
So,
what's a red flag if someone's giving you a contract or maybe has
yeah,
taken this contract
yeah.
and inserted
So
something in there?
yeah, I would say one of the biggest red flags is adding a grant of rights to something that is really completely irrelevant. Like that they don't need this other set of rights that they're asking for. For example, um, if you're providing some composition work to an organization or person, if they want you to be exclusive to them and you can't create for anybody else, that's probably excessive. So long as you can get the work done, you should be able to have other clients and other things that you're doing. So I think that I would caution. I would always do like control find the word exclusive. Am I giving any kind of exclusivity for me and my time, over any kind of time period? So that's one thing. And a related concept is that, and this isn't. I would answer this question in the context of an artist entering into like a record label deal, where the artist is entering into an agreement with a music label, and the music label also wants to be their publisher representing their compositions. And I would say to them, depending on the circumstances, they don't need that right to your compositions if their main goal is being your distributor of your recordings that you own. They don't also need to also be your music publisher, or if they also want to be your booking agent or your manager or your exclusive merchandise people. It's like what do they need to do the thing that they're being brought on to do, and then what are all these extra things that they're asking for? Maybe you don't want to also give all these extra rights just yet. You want to focus on what they actually need to do the main thing that they're doing. So the red flag is being asked to give more rights than what is necessary for the service or thing to happen. Like what is additional that's really not needed. And the third thing that I referred to a bit earlier, I lost my train of thought there. Providing things, red flag. You know what? I lost lost my train of thought on the final thing, but yeah, just being asked to give more than you really are. That's being more than what's necessary to give. Oh, sorry, I now remember. If you're promised something that's not in the agreement, and you're told, "Oh yeah, don't worry, just trust me, this will happen." I call that a just trust me agreement. Where you're being told something, but if someone is not willing to put it into the agreement, the question is like, why? So, if you're promised a certain thing and you can, whatever you want to say in anything that you're promised, in addition to what you're contractually entitled to, if someone is not willing to put that into the agreement, they're asking you to trust them, and that's either relevant or it's not. It's either appropriate or it's not appropriate. But, I would call it a just trust me agreement. So that's something else that I would look out for. I would look out for people or companies that are not willing to document what they've promised that they will do.
That's good. Those are good. I like the control F exclusive.
Yeah,
That's like I'm gonna find a place to put that on our website.
yeah, yeah.
Joel, that was your question. I was just wanting to check in with just that was what you were after and what you were kind of wondering about.
Yes, indeed. Thank you, Byron.
Perfect. Um, does any before I ask the question that's popped into my oh, here's one. Are email agreements considered contracts?
Um, our email agreements. So, I mean, what do we mean by that? I mean, if you, okay, so as long as there's offer acceptance and both sides are getting something consideration, you can confirm that over text message. You can confirm it over email. You can confirm it by having a contract that you both sign, digitally or in writing with a wet signature. So there's the way that you do that in writing. They're all legally binding. Um, Within intellectual property, it does need to be in writing to transfer ownership of intellectual property, but that can be done by way of, I email August and I say, hey, I'd like to hire you to do these things, um, or I want to sell you my, my bottle of whatever, and he says yes, and we have a transaction there, and the fact that it was done over email and not with a formal agreement, that's okay. The big divide is when we're talking about verbal agreements versus written agreements. And that's where you can get into some issues if an agreement is discussed verbally, not documented anywhere. People might forget what they agreed to. People might lie about what happened. And some people do that sometimes. And also with intellectual property, as I said a moment ago, it's not legally transferred unless it's in writing for intellectual property here in Canada. So there's a lot of value in having agreements be in writing, but within that writing, that can be via email or other written form. If you last comment on this, if two people are texting about a situation and are agreeing to something over text message or WhatsApp or something like that, um, that's fine. But what if your phone falls down the sewer? So if there's something really important that you're agreeing to via text message, my suggestion is to take some screenshots of your texts and send them to yourself by email. Now, don't lose your email password, but don't just rely on text message. I would say I think email is just a lot more secure, but we all have an old email. I can't access my Hotmail address from the 90s. So um, I would suggest trying to make sure you have copies of things if they are being digitally confirmed. Same with a contract. I mean, if you have a contract that's in writing that you both, you write it out, you print it out, you both sign it. Don't just have one copy lying around. Take a picture or scan it and email it to each other. So, written documentation in any kind of way or written confirmations, and then make sure that you have ways to keep track of them. If you're using one of these, the templates that we've been talking about, or this one from today, you customize it for your needs. You provide it to the person, see if they agree. They may have some proposed changes. You finalize your agreement. You both sign it, whether in person or whether digitally using like a digital signature app. You both have a copy of it. Hopefully you have a copy of it in your email, and you kind of you keep your contracts organized and in the same place, so you can you know where to look if you need to find something. So a lot of this is about just organization of things that you've agreed to and keeping track of who you have obligations to, what obligations people have to you. We're talking about compositions, making sure they're properly being registered and taking a look to see your registrations are happening. So, there's a lot of organization within music. And now I'm rambling on a little bit, but like keep track of your email contracts is my answer to the original question.
Okay. Any other questions before I ask one final question? Doesn't look like it. Okay, here's my question, because we talked a lot about arrangements, and I hope I'm not opening a Pandora's box here. If a composer is hired to do an orchestration and an arrangement of a pre-existing, well, it's by default a pre-existing work that's not in public domain, so it's got its own
Yeah.
ownership.
Yeah.
What does the composer doing the arrangement have the rights to?
Well, if so, is the engager the person who created the original work?
Let's say no. Let's say the TSO has hired me to do an orchestration of a Justin Bieber tune.
His publisher needs to get permission.
Right.
So, like, so,
Well, presumably the TSO has got permission to do this. They've then
okay,
hired me.
right,
What
but
happened? Yeah,
sure,
sorry, go ahead.
but they would need to get. Not only are they getting permission to make this new work that's, I assume, being performed, but they also need to clarify what percentage of the composition is available to be provided to you.
Okay.
And they can't give you and Justin Bieber's people and, I mean, co-writers, they can't collectively give out more than 100% of the ownership
Right.
of the new composition. And so, if you or anyone else is asked to adapt or arrange or create a derivative work, a new work based on an existing work, in terms of your due diligence, among other questions, you might say, um, what rights have you received from the original creator or representatives of the creators? Like, what rights do you have, and what was discussed about the new compositions being created? And depending on the circumstances, you may want proof of it, because you don't want, like, you want to make sure that you're covering yourself. This is also where the representations and indemnity comes in. So let's bring it back to that section. If you are being asked to adapt Justin Bieber's first album in a certain kind of way, and they're saying to you, yeah, we got permission and we're going to give you August, we can allocate 10% of the new composition to you. I know it's not a lot, but like, we're talking about this special project, and we're not allowed to give more than 10%. You might say, like, okay, but in the representations section, you're having the engager confirm that they got permission from the publisher, from all of the relevant publishers, and that they're confirming that you are allowed to get 10% of the new composition, and they're indemnifying you if that wasn't the case. So if the deal with if they never got permission from the people who published, from the publishers of the compositions in question, and the publisher came after you, you could in turn go after the engager to cover you for any losses that happened. Now, for a very reputable organization, they're never going to lie to you about what happened, but not everybody fully knows what needs to be done to get proper permissions. And so, I would encourage you, or anyone, if you're being asked to adapt or arrange or create a derivative work based on something else, is to ask questions, see confirmations of things. You may not be able to know the full deal. If you're being given if you're asking for a part of an agreement, or an agreement that has some, like, lines through it, you're asking for what's called a redacted agreement. And this may be a bit excessive in most situations, but asking about what rights they've received, and having the agreement confirm that they got the rights, and that they're indemnifying you with respect to the splits of the new composition, you're in a better position than just assuming everything is fine.
Gotcha. Okay. That roughly.
The related question is, like, well, what's reasonable? What's a reasonable share to get? And it again kind of depends on the situation. But yeah, it's kind of like all over the map sometimes in how those are split. But personally, the most common situation I'm in relating to these kinds of situations are when an artist is sampling another song, or interpolating a song, which means to take the essence, the idea, maybe the words, maybe the lyrics, maybe the melody, and creating a new song based on that original. And oftentimes the owner of the original composition get 50% of the new composition, even if there was a pretty, like, minor contribution, or minor use of the original. So oftentimes it's a 50-50 split between the original and the new. original writers and the new people. Other situations, it just depends on kind of the actual contributions. So no right or wrong answer, but there's some different considerations that sometimes come up.
Okay. Yeah. I'm reminded, I think it was Stravinsky, good composers borrow and great composers steal. So, there you go. One last question. Are people able to engage your services if they have contracts or waivers that need looking
For
over?
sure. For
Okay.
sure. Yeah. I'll put my email here again in the bottom, and it probably is connected to the agreement in some way. But yeah, I'm happy to if someone is looking for some additional assistance in having an agreement reviewed or prepared, including based on the template from today and the template from earlier. That's kind of all I do every day is write and review entertainment agreements, mostly music, but also film and TV stuff. And yeah, happy to help on that front as needed.
Awesome. Well, I think if that's it, then I want to say thank you, Byron, for all your work, not just today at this very like super duper informative presentation, but also on the contract itself. I think it's going to be a really valuable service to our community. And thank you to everyone for coming today and for bringing some questions. And a reminder that the contract is on our website. There's two versions you can find on our website. One is a PDF, the other is a Word document that has some embedded comments from Byron that sort of explain a few things. And this webinar it's got to be translated first, but this will go on the website. And if you ever need to reference it or come back to it. And of course, if you have any questions, you can email me and I will do my very best to answer them. So thank you very much.
Great to be here. Good luck, everybody. Keep in touch. Talk soon.
Okay.
Bye.
Bye.